Good morning, Your Honor, and ladies and gentlemen of the court. Representing the state of Indiana in the case of State of Indiana versus Mitch Ritchie, I, Corey Tucker, prosecuting attorney and appellant oral arguer, on behalf of the prosecution team, I am motioning to compel these courts to uphold the decision made previously. The defense is appealing the decision made in this court on the grounds of improper representation by the defendant's legal team. The premise that the defense counsel is basing the appeal on is two different matters of the law that shall be discussed. The first matter at hand is the testimony of the nurse that treated Mitch Ritchie, Bo Derek Morgan. The defense states that the nurse's statement should have been included, therein the motion in limine to be excluded from the trial. The reasons that they have behind this are as follows: violations of the Federal Rules of Evidence 501, and the Health Insurance, Importability, and Accountability Act of 1996. While the defense states that it is a violation of the Federal Rules of Evidence 501, they continue to say that it is not a violation, since Federal Rules of Evidence 501 does not mention the privilege of physician-patient confidentiality. The common law of Federal Rules of Evidence 501 states the following: as interpreted by the United States courts in the light of reason and experience governs a claim of privilege unless any of the following provides otherwise: the United States Constitution, a federal statute, or rules prescribed by the Supreme Court. But in a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rules of decision. While Federal Rules of Evidence 501 has listed that a state governs privilege, that is in a civil case, not a criminal case. They go further on to cite Indiana Code 34-1-14-5 on physician-patient confidentiality, while in fact it is Indiana Code 34-46-3-1 that says the following: except as otherwise provided by statute, the following persons shall not be required to testify regarding the following communications: physicians as to matters communicated to them by patients in the course of their professional business or advice given in such cases. Now let me ask you, what is the legal definition of a physician? To clear this definition, the prosecution diverts you to the definition provided by Cornell Law. The term physician includes doctors of medicine, MD, surgeons, pediatrics, dentists, clinical psychologists, optometrists, chiropractors, and osteopathic practitioners within the scope of their practice as defined by state law. The term includes chiropractors only to the extent that their reimbursable services are limited to treatment consisting of manual manipulation of the spine to correct a subluxation shown by X-ray or clinical findings. Physicians defined in this part may interpret their own X-rays. All physicians in these categories are authorized by the director to render medical care under the Act. Naturopaths, faith healers, and other practitioners of the healing arts, which are not listed herein, are not included within the term physician, as used in this part. So does Nurse Bo Derek Morgan fit the description of physician? No, she doesn't. Law is not up for interpretation in this matter. In order for law to not be struck down and voided for vagueness, they must be sufficiently clear. So if they must be sufficiently clear, then we must interpret both the law and the legal definition at face value. Due to the prestige and educational requirements, it is logical to say that these common factors conclude that the definition is based on a system rather than the arbitrary thought. Now to discuss HIPAA. While this HIPAA does not cover confidentiality, it does cover the process that anyone has to go through to gain access to medical records of an individual. Nurse Bo Derek Morgan did violate the process in place for disclosure of medical information, but she did not have the knowledge that the person she confided in was a detective. The use of the information she provided in the courtroom was only testimony of what she told the detective, and a medical opinion of the kind of burns on the defendant, Mitch Ritchie. The burns found on Mr. Ritchie were found to be chemical burns commonly associated with explosions in the methamphetamine production, such as the one found at the site of the first arson. While telling a detective about the burns, it is her duty to report such injuries under Indiana Code 35-47-7-1, which covers the mandatory reporting of non-accidental injuries. With the nurse being required to inform law enforcement, in combination with the other claims, the defense informed the court that they intend to claim the information obtained from the nurse and the evidence from the search warrant to be excluded due to the fruits of poisonous tree doctrine, along with the testimony of both detective and fire investigator on the scene. However, the information provided by Nurse Morgan fits into one of the exceptions to the fruits of the poisonous tree doctrine. The exception to it is the information was both discovered from a source independent of the illegal activity. Moreover, its discovery was inevitable due to the severity of the burns on the accused taking an extended amount of time to heal. If the nurse was doing her duty, she would have reported the injury, as well as the surveillance video of the accused confirmed on who it was by the owner of the property. Claims that the detective targeted Mitch Ritchie based on what he was told was inaccurate, since before the investigation into Mitch Ritchie, the detective was advised that the video shows Mitch Ritchie breaking into the property that was later set in flames. The advisory information came from law enforcement officer Brandon James. So while the information provided to the detective did aid his overall investigation, Mitch Ritchie was already a key suspect. Moreover, the testimony of Duff Evans is sufficient information for a warrant due to both his testimony and the video evidence that clearly shows the accused. Chief Fire Investigator Jenna Ireland did not get her identification of Mitch Ritchie from the nurse like the defense states. In the report provided by the fire investigator, she states that she identified Ritchie based off of the surveillance footage. The phrase "didn't see him commit a crime" is repeated by the defense, but I must ask, does video evidence showing Mitch Ritchie unlawfully entering a property with the intent to commit a felonious act not constitute as seeing him commit a crime? It is the opinion of the prosecution that indeed that it does constitute a crime and criminal behavior. Now the question that I present to you is, would this court rightfully uphold the conviction passed down from the sentence provided and uphold justice in the just society? On behalf of the prosecution, the County of Delaware, the State of Indiana, I request that this conviction be ratified and the appeals made by the defense to be repudiated. With deepest respect, Corey Tucker. Thank you.